This is Medical Device Legal News. Today is April 4th, 2023. Thank you for joining us today. This weekly podcast will focus on recent legal developments for medical device manufacturers, including enforcement actions, guidance documents, and other legal news. My name is Sam Bernstein. I'm a partner in McGuire Woods Healthcare Group, and I focus my practice on representing medical device manufacturers on a wide range of compliance, regulatory, and transactional matters. Last week, in a consolidated False Claims Act Supreme Court case involving Safeway, SuperValue, and other pharmacy providers, approximately 20 industry groups, including AdvaMed, the American Medical Association, the American Hospital Association, and the U.S. Chamber of Commerce, urged the Supreme Court to adopt the objectively reasonable standard for determining whether a defendant acting knowingly under the False Claims Act, amid a circuit split regarding the scienter requirements for violating the False Claims Act. This case involves a dispute over drug pricing and specifically regarding what the term usual and customary charge means when pharmacies charge Medicare, Medicaid, federal government programs for the products that were dispensed to governmental program beneficiaries. There were relators that initiated this lawsuit against the defendants under the False Claims Act. As you may be aware, the False Claims Act prohibits, among other things, knowingly presenting or causing someone to present a false or fraudulent claim for payment or approval to the government. Knowingly is defined as having actual knowledge of the truth or falsity of the information, acting in deliberate ignorance of the truth or falsity of the information, or acting in reckless disregard of the truth or falsity of that information, and requires no proof of specific intent to defraud. The penalties for violating the False Claims Act are very substantial, treble damages, plus a significant per claim penalty that adjusts with inflation, which is currently between $13,500 to a little over $27,000 per claim. This case is really about the interpretation of the ambiguous term usual and customary charge and whether or not these pharmacies violated the False Claims Act when they submitted charges to the federal government, depending on how they interpreted what usual and customary charge meant amid uncertainty and ambiguity regarding what that term means in various programs. The relator's position, the key time relator's position, is that a party can violate the False Claims Act even if they act in a manner consistent with an objectively reasonable interpretation of an ambiguous provision, if the defendant subjectively knew or believed or had reason to know or believe that their conduct was unlawful. In this case, even though their interpretation of usual and customary may have been objectively reasonable, the relators contend that the defendants knew that their conduct was unlawful and therefore violated the False Claims Act or believed so. The industry amici are urging the Supreme Court to adopt the same standard that it adopted in a 2007 Fair Credit Reporting Act case involving Safeco. That standard was that an objectively reasonable interpretation of an ambiguous provision cannot give rise to liability under the Fair Credit Reporting Act, and in this case it would be under the False Claims Act, unless authoritative guidance warned the person away from that interpretation. As a compliance attorney that regularly advises clients on anti-kickback and False Claims Act issues, these are exceedingly important cases. Many laws, rules, and regulations in the healthcare and life sciences industry, including Medicare and Medicaid programs, Food, Drug, and Cosmetic Act laws and regulations are ambiguous or unclear. Clients often rely upon the interpretation of these ambiguous laws, rules, and regulations and often go to legal counsel. If these interpretations are objectively reasonable, clients should be able to rely upon them when addressing False Claims Act exposure, regardless of whether a stakeholder has lingering concerns or belief that the conduct may be unlawful. What matters is what is objectively reasonable, or what should matter is what is the objectively reasonable interpretation of an applicable law or regulation, as that is how laws and regulations are interpreted. On March 24th, CDRH issued 2 final guidance documents to assist with transition plans for medical devices that were issued EUAs or fell within certain enforcement policies issued in response to the COVID-19 pandemic. HHS will publish advance notice of the termination of each EUA declaration under Section 564 of the Food, Drug, and Cosmetic Act 180 days before the EUA declaration is terminated. The FDA has asked manufacturers of reusable, life-supporting, or life-sustaining devices issued an EUA to notify CDRH if they intend on submitting a marketing submission. The FDA is also recommending, if you submit a marketing submission, that you include a transition implementation plan to address devices that you've already distributed in the event of a positive or negative decision. The FDA also, interestingly, indicated that, subject to certain safeguards, will exercise enforcement discretion for the continued distribution of devices after the expiration of an EUA. If the manufacturer has submitted a marketing submission for that product and it's accepted before the EUA termination date, and the FDA has not yet taken final action on the marketing submission. There's also some guidance regarding how those devices may continue to be labeled under the prior EUA that has expired during the pendency of the marketing submission decision. Guidance document also addresses certain considerations for EUA authorized in vitro diagnostic tests and addresses steps manufacturers may take if they intend to discontinue the distribution of their product upon the EUA termination date, including sending labeling changes to customers. The FDA also signaled that it will entertain requests for variances to quality system requirements for products that were subject to an EUA, and asked that those requests be submitted within 90 days of the publication of the advance notice of the termination of EUA declaration. With respect to the guidance document for products not issued an EUA but distributed under enforcement discretion, many of those guidance documents established a deadline, expiration deadline, 180 days after the public health emergency declaration expires, currently expected to be May 11, 2023. So for many of them, 180 days after that deadline. The guidance document did not change those deadlines, but you should look at the guidance documents that your device is currently being distributed under to ensure that you have the correct deadline, as not all of them fall within that guideline. Similar to the guidance that the FDA issued for EUAs for devices distributed under guidance, the FDA, again, subject to certain safeguards, does not intend to object to continued distribution of devices within the scope of enforcement guidance if a marketing submission was submitted and accepted before the expiration of the relevant guidance, i.e. 180 days after the declaration expires, and the FDA has not yet taken final action on that marketing submission. These are important guidance documents that if you have products that you've been distributing under an EUA or enforcement policies that you should review, and you should develop a strategy for obtaining market approval or discontinuing your products or market clearance for your products before the expiration of your EUA or the relevant enforcement discretion. Last week, on March 29th, the Office of Inspector General of the Department of Health and Human Services posted Advisory Opinion 2303 regarding a proposal from a manufacturer of a non-invasive colorectal cancer screening test to provide a gift card of up to $75 to encourage patients to return a sample colorectal cancer screening kit when they were late in returning the test to the laboratory. The test was recommended by the U.S. Preventive Services Task Force. It was also recommended by the American Cancer Society. Relevant limitations in the advisory opinion included that the gift card would only be provided if the kit was returned on time by a specified deadline, that the patients would be told that the gift card could not be used with the manufacturer or the laboratory. The patient would be limited to receiving one gift card within a 36-month period, and the manufacturer would adopt policies to ensure that that standard was adhered to. The manufacturer would not engage in patient-focused promotion of the arrangement or otherwise market or advertise the arrangement, and the gift card would not be available if the test was ordered through the manufacturer's website. The determination in this case, the OIG determined that they would not impose sanctions under the beneficiary inducement prohibition provisions of the civil monetary penalties law due to its qualification of this incentive under the preventive care exception to the beneficiary inducement prohibition. They also determined that they would not impose administrative sanctions under the federal anti-kickback statute. Their reasoning for this decision was primarily based on the fact that the arrangement would not induce patients to obtain other services that are reimbursable by federal healthcare programs, that there was no incentive to the prescriber, that the test was recommended by the U.S. Preventive Services Task Force, and that the manufacturer had adopted the foregoing safeguards that I mentioned. As a reminder, advisory opinions may not be relied upon by any party other than the requester. Accordingly, if you are considering some sort of preventive care inducement to patients to promote adherence to applicable treatment regimen or instructions or deadlines for returning information or samples to a laboratory or otherwise, recommend that you discuss those structures and those inducements with legal counsel, as these types of arrangements may implicate the federal anti-kickback statute as well as the beneficiary inducement prohibition. On March 21st, California OSHA issued 18 citations to medical device sterilization company Harder Medical Products, alleging that it failed to protect its employees from ethylene oxide. Amid a growing battle over EPA-crafted risk levels of the substance, they were seeking penalties of a little over $800,000. If you use ethylene oxide in your manufacturing and sterilization processes, you may want to review and keep an eye on the current battle with the EPA, as well as any state law and OSHA-related standards in your jurisdiction, as it appears that there is an uptick in enforcement, and we expect continued focus in this area. Again, my name is Sam Bernstein. I'm a partner of Woods Healthcare Group, and I appreciate your time today. Look forward to seeing you next week on Medical Device Legal News.